The legal battle surrounding the movie It Ends With Us was possibly the defining Hollywood conflict of 2025. A multi-headed hydra involving sexual harassment claims, a creative coup, and the dark arts of SEO. Entire ecosystems of mommy sleuths and law tubers have emerged to dissect every court filing, and public opinion is split. On one side, Blake Lively, alleging sexual harassment and a retaliatory smear campaign. On the other, Justin Baldoni, claiming defamation and a hostile takeover of his film. These are serious allegations. They deserve to be treated as such. But this analysis is not about them. Not directly. Instead, we're going to focus on two PR representatives, an employer in Connecticut and an employee in California, and the single mobile phone that set everything else into motion. Because regardless of which team you're on, the legal maneuvers beneath the surface of this Hollywood PR crisis should give us all pause. This is the story of how a 33-year-old executive's entire digital life, her texts, her bank access, and her medical records, was packaged and delivered to the front page of the New York Times without her knowledge. And the premier army of lawyers that navigated gray areas of legal process to make this happen. This is an autopsy of a PR crisis. It all began on August 21st, 2024. Jennifer Abel, PR executive and partner at the A-list talent agency Jones Works, arrived at her Beverly Hills office for what she expected to be a standard workday. Abel had resigned weeks prior, giving a full 6-week notice, and had only 2 days left at the company. Upon arriving, Abel was led into a conference room by the company's chief of staff and met by 3 individuals: a security guard, a forensics technical expert, and an attorney from a leading media and entertainment law firm. There, Abel claimed she was pressured to sign documents while her work laptop underwent a forensic sweep. The meeting concluded with a demand for Abel's phone, a company-issued iPhone that apparently housed her entire life. While the device was the company's, Abel claims to have carried the same phone number for 15 years, long before she ever joined the company. According to Abel's legal filings, both the firm and its attorney told Abel they needed her passcode for one reason: to port her long-standing number to a new device. They promised that if she drove directly to a Verizon store, she would have her number and her data transferred back to her within a matter of minutes. Jennifer Abel did exactly that and waited for hours for her number to be ported. But she claims it never was. The number was never released. The impact was immediate and total. With the number Abel's had since her teenage years now inaccessible, Abel claims she was locked out of virtually every account protected by 2-factor authentication. Her iCloud, her bank accounts, her medical portals, and even her 401k vanished behind security protocols meant to keep her data safe. But the story doesn't end with loss of access. Fast forward to December 21st, 2024, without a single word of warning, Jennifer Abel says her private life was laid bare across the front pages of the New York Times, used as evidence of an alleged smear campaign against a victim of sexual harassment.
A publicist who had already been working with Baldoni wrote to Nathan, "He wants to feel like she can be buried. You know we can bury anyone," Nathan wrote, "but I can't write that to him."
The article in question reported that Jennifer Abel's texts, ranging from high-level professional strategy to deeply personal private conversations, were obtained through a subpoena and attached to a court filing involving one of the most recognizable names on the planet, Blake Lively. The Times had also, apparently, been reviewing these records for weeks, thousands of pages of text messages and emails, according to their own reporting. And seemingly no one had actually seen the subpoena. Not Jennifer Abel, not the people she had messaged, not even the defendant to the harassment complaint, Jen's client, Justin Baldoni, had any idea these texts had been requested, let alone handed over to the media. This is no longer a workplace dispute, nor is this just a clash between 2 celebrities. This is a procedural horror story involving some of the country's most powerful law firms working together to transform private data into a public narrative. Those following the Lively and Baldoni proceedings may be familiar with the Van Zandt subpoena. In the legal world, a subpoena is an instrument using the power and force of the courts to find information. It forces the recipient to produce requested documents, under threat of legal sanction, or at least to provide a good legal reason why you can't. Usually, but not universally, an element of a subpoena is notification, that the people adversely impacted by a subpoena are given an opportunity to review the request, respond, and if deemed necessary, apply to quash the subpoena. And it's notable that no notification was given here. This mystery around the subpoena that was used to obtain Jennifer Abel's texts, mentioned in the New York Times reporting but nowhere else, remained unsolved until April 17, 2025, when Daily Mail's Josh Boswell reported that they had seen a subpoena addressed to Abel's former employer, JonesWorks.
A source came to us and showed us a copy of this subpoena that looks like, it was sent to her and it asked for all of this information. So that was kind of the initial story was, hey, look, there is actually a subpoena. But then we dug into it a little more, and that's, I think, where it got really interesting.
The subpoena was dated October 1st, 2024, and issued from a mysterious entity called Van Zandt Inc. Internet sleuths quickly discovered that Van Zandt wasn't an active trading company, but instead a shell or holding organization. And moreover, speculation emerged that its name was a portmanteau of Vancouver and Tarzana, pointing to the hometowns of Blake Lively and her husband, Ryan Reynolds. Further, according to the Daily Mail's reporting, the subpoena bore no court stamp. The world wouldn't see the document itself until the 20th of January this year, when it was unsealed as Exhibit 250 of the Lively Baldoni litigation. The cover page of the subpoena places it as part of a John Doe proceeding in the Supreme Court of New York, a legal maneuver often used to hunt for information against unknown or anonymous parties. You use the name Doe when you're not yet sure who to sue. The subpoena was issued specifically to Stephanie Jones, the CEO of Abel's former employer, JonesWorks. So the mystery was solved. The person behind Jennifer Abel's texts ending up on the New York Times is Stephanie Jones. So who is Stephanie Jones? Stephanie Jones is the very successful CEO of JonesWorks, a talent and PR agency representing globally recognizable names like Dwayne Johnson, Tom Brady, Venus Williams, and Chris Hemsworth. Stephanie Jones was also Jennifer Abel's boss, with Justin Baldoni being their mutual client. There is an ongoing litigation between Jones and Abel, the full scope of which extends beyond this particular analysis. I mention this, however, as it's over the course of these legal proceedings that we've learned some background information about the seizure of Jennifer Abel's phone. According to both legal filings, the friction between Jones and Abel began with the introduction of a third character, Melissa Nathan. Melissa Nathan is a PR agent specializing in crisis management, and according to Stephanie Jones, a practitioner of the dark arts of PR. Nathan's claim to fame is representing Johnny Depp during his defamation claim against Amber Heard. In her pleadings, Jones accuses Melissa Nathan of engaging in a regular practice of creating highly offensive and negative online content against individuals, often influential women, including Jones and JonesWorks, with the clear intention of destroying those individuals' reputation. So when Abel looped Nathan in on the Baldoni account to help with the It Ends With Us PR crisis, a major schism formed between her and Stephanie Jones. Abel describes Jones in her legal filing as acting in a volatile and unraveling manner, including making decisions on the basis of psychic readings. For example, Abel alleges that it was following two such psychic readings that Jones accused Abel of suffering from alcoholism and a gambling addiction, as well as predicting publicly that Abel would become pregnant with twins, despite known struggles with fertility. I should clarify these are allegations in a highly contentious lawsuit and should be taken with a grain of salt. Jones meanwhile points the finger back at Abel. According to Stephanie Jones, Abel and Nathan had helped coordinate a hit piece article against her in Business Insider titled "Who's Afraid of Stephanie Jones?", describing a hostile work environment at JonesWorks. Jones's legal filing alleges that Nathan and Abel were active participants, if not masterminds, behind this hit piece. Jones alleges that Abel had stolen up to 70 confidential documents, with the aim of poaching JonesWorks clients, including globally recognized names. It is in this atmosphere of distrust that Abel's phone was seized. Stephanie Jones's legal filings confirm that she believed Abel's phone would show evidence of both the stolen confidential documents and the coordinated effort between Abel and Nathan to destroy Jones's reputation and steal clients. And since Abel's phone was a work device, Steph Jones says the data on it belongs to JonesWorks. It is essential to acknowledge that Stephanie Jones wasn't acting without a stated cause. Her filings allege that Abel had taken up to 70 confidential documents with the intent to poach high-value clients like Dwayne Johnson and Tom Brady. From a business perspective, Jones had a legitimate, compelling reason to want to see that data to protect her agency's trade secrets. This is a very gray area of law. If you're using a work device for personal purposes, including private texts, photos, and medical records, is that data yours or your employer's? In the opinion of Stephanie Jones and her legal team, it's the latter. And Stephanie argues she has a compelling, motivating reason to claim that data. If her sensitive client information is being shared for illegitimate purposes, she needs that data to determine the extent of the damage done and mitigate harm. However, in California, where Jen Abel resided and worked, the law is arguably more protective of employee privacy than other states. Within the Golden State, employees have a reasonable expectation of privacy, even on work-issued devices. This protection is especially the case when the company doesn't have a clear written policy regarding phone use. And in the case of JonesWorks, they didn't have one. No employee handbook, no signed electronic use policy, nothing. So Jen Abel has an arguable case that her personal data was taken from her in violation of her legal rights. And this case is currently being heard in court. But what's interesting is that despite the questionable grayness of the seizure, the data made its way to the New York Times. How does that happen? The closest model we have for describing the conversion of legally questionable data to publicly printable data is money laundering. The term laundering is commonly associated with legendary gangster Al Capone. At the height of his power, Capone ran a complex bootlegging operation across Chicago and parts of New York during the height of Prohibition, with his main sources of revenue being from distributing alcohol, running speakeasies, and gambling. But this was, obviously, not money he could report on his tax filings. The solution? Laundromats. Capone purchased legitimate businesses, including laundromats, and used them to obscure the source of his questionably legitimate funds. The money from Capone's laundromats and other businesses would appear like clean profits from a successful and thriving business, despite most of it originating from bootlegging. The actual term money laundering didn't appear regularly until the 1970s and 80s with the establishment of the Financial Action Task Force, a global initiative to track the flow of money in complex financial crimes. While Al Capone is the face of money laundering, our modern understanding of money laundering comes from another mob figure, Meyer Lansky. Lansky grew to prominence after the fall of Capone and saw the latter ultimately get caught and convicted for tax evasion, of all crimes. Lansky learned from Capone's capture and developed his own three-step process for laundering money: placement, layering, and integration. Step 1 of Lansky's operation was placing money into a financial institution, usually an offshore bank account, away from federal interference or oversight, but importantly, into a recognizable financial system that can do business in the United States. This is the equivalent of the coin slot in the laundry. Stage 2 was layering the money with a series of transactions. Lansky's specific trick was loaning his own money back to himself, using different corporate entities. And by creating a chain of transactions, the money becomes very hard to follow. Eventually, the money would come out the other end 100% clean and legal. And stage 3 was integrating the laundered funds back to the economy by purchasing real estate or high-value goods like jewelry or art. The Lansky model is still used by anti-money laundering organizations as a way of conceptualizing the movement of funds while obscuring their origin. And while I don't believe anyone intended this, the effect of the Van Zandt subpoena was to wash Jennifer Abel's phone data of the questionable legal status of its seizure. To be absolutely clear, I'm not suggesting that the law firms we've discussed operate like a criminal enterprise. Simply that Lansky's model is a structural and functional mirror demonstrating the mechanics of how a process, a series of transactions, can be used to move a commodity like data from a gray origin to a clean public destination. In California, employees have a higher degree of reasonable expectation of privacy when compared to other states. So for any attorney with a familiarity with California privacy laws, alarm bells should have been ringing during that August 21st meeting. According to Abel, her phone was confiscated in the presence of an attorney from the firm Frankfurt Kernet Klein & Sells. This is a crucial detail. Frankfurt Kernet are the privacy lawyers, having an entire division dedicated to data strategy, privacy, and security. We don't know the name of the attorney in question or their particular area of practice. But if anyone could advise Stephanie Jones on the legal risks of harvesting personal data from a California employee, it was them. Yet despite the risks, the seizure happened. This was the equivalent of a placement moment in Lansky's model. We now know the data from Abel's phone didn't stay at Jones' Works. It made its way to Blake Lively, to her legal team, and it even traveled across country to the servers of the New York Times. The Van Zandt subpoena was sent to Stephanie Jones and Jones' Works, but not to her office address. Instead, it was sent to Quinn Emanuel Urquhart and Sullivan, a New York law firm known for high-profile disputes. Now, Quinn Emanuel is not Frankfurt Kernet. Both are blue-chip, top-tier law firms, but for reasons unknown, Quinn Emanuel, not Frankfurt Kernet, accepted service of the subpoena. Intentional or not, this creates a layering effect. The firm that seized the phone is different from the firm that transferred its data to an adverse party. Typically, third-party subpoenas are a surprise, a knock on the door demanding documents. But to serve a subpoena on a law firm, you need to know in advance that the firm has instructions to accept service. This suggests that there may have been prior correspondence between Quinn Emanuel and Van Zandt's legal team. Quinn Emanuel likely knew that a subpoena was coming before it was issued. The subpoena was issued by Manat Phelps, the same firm representing Blake Lively and Ryan Reynolds in the Baldoni dispute. And the data eventually makes its way to the New York Times, represented by Davis Wright Tremaine. Now, when we look at the chain of custody of Jen Abel's data, it begins to look like a chain of law firms. With potentially the exception of Davis Wright Tremaine, all of these law firms likely had possession of Jen Abel's texts at one point or another, prior to the publication of the New York Times article. To recap, Frankfurt Kernet facilitated the seizure of the phone. Quinn Emanuel turned the data over to an adverse party. Manat initiated the whole process with their subpoena and ultimately turned over the data to the New York Times. And the New York Times was represented by Davis Wright Tremaine, who defended the paper's right to publish it. With each transfer between entities, we lose two things: visibility and knowledge. Manat likely knew less about the questionable circumstances of Jen Abel's phone seizure than Quinn Emanuel, and Davis Wright Tremaine even less so than that. With each new law firm assuming custody of the data, it begins to look cleaner, better vetted, more legitimate. And it's arguably not the law firm's fault. They don't know what they don't know. They are insulated by the procedure. I can't confidently say the law firms issued the Van Zandt subpoena with clean hands, despite my personal hope they did. There is a docket number on the Van Zandt subpoena, and looking into that, you see that there were only ever 2 documents filed in that case. The first was a complaint, issued by Van Zandt against does 1 through 10 on September 27, 2024. The second is a notice of discontinuance, filed on the 19th of December 2024, merely days before the New York Times article. All 3 legal documents were issued by senior equity partner at Manat, Samantha J. Katz. And they describe an apparent contractual dispute between Van Zandt Inc. and up to 10 anonymous parties. Reading through the Van Zandt complaint establishes a clear narrative. Does 1 through 10 had a contractual obligation to Van Zandt that included but was not limited to confidentiality. And according to the complaint, they breached that obligation by disclosing that information. Yet despite the certainty of the contractual obligations and their breach, Van Zandt apparently doesn't know who these individuals are, and requires the assistance of the court to find out. A legal quirk of the Van Zandt complaint I'd like to highlight is that, despite not knowing who does 1 through 10 are, Van Zandt is confident they live and or work in the state of New York. It does beg the question of how. We don't get an answer to that in the filing. A cynical reading of the Van Zandt complaint is that it is a legal fiction, an invented dispute between a company that doesn't do anything against anonymous individuals who don't exist. And this skepticism appears to be shared by the presiding judge in the case, who has allowed a full discovery into the origins of Van Zandt and the parties that funded it, stating that if it was used to bypass standard rules of discovery, that would be a matter of significant concern. Quite likely, Samantha J. Katz appears to have bent the rules but potentially not broken them. The state of New York allows for the issuance of Doe suits when the defendants aren't known, and Blake Lively's claim is that there was a clandestine retaliation campaign involving multiple unknown actors. You're allowed to go fishing if you have reasonable cause to believe you're in the right place. The problem is the entity. Blake Lively and Ryan Reynolds have multiple organizations tied to their names, and they all serve different purposes. Blakel Inc. is one such entity that Blake used to contract with Justin Baldoni and his production company Wayfarer. Blakel Inc. has a much better standing to issue this kind of subpoena than Van Zandt, who doesn't appear to have any contractual relationship with any member of the It Ends With Us production. And by leaving the Does in the suit completely blank and not adding known names like, for example, Justin Baldoni, the Van Zandt subpoena avoids the notification safeguards in place for most subpoenas. If Justin Baldoni was listed as a defendant, then he, and presumably Jen Abel, would become aware of the subpoena and have a right to review what was disclosed in response to it. The Van Zandt subpoena was issued to Quinn Emanuel, a law firm known as Powerhouses in Litigation. It's worth noting that despite being part of a Doe suit, the Van Zandt subpoena has plenty of names in it. Blake Lively, Ryan Reynolds, Justin Baldoni, It Ends With Us. This arguably should cause alarm bells for any third-party recipient of a subpoena, especially a powerhouse in litigation firm like Quinn Emanuel. In an older client alert issued by Quinn Emanuel in August 2014, they described the significant expense of complying with third-party subpoenas and stressed the importance of immediately objecting. By immediately objecting to a subpoena, the third party can shift the expenses incurred with complying with that subpoena to the requesting party. This seems to be a legal strategy that Quinn Emanuel recommends to most of their clients. Don't cooperate, make them pay for your work. But there's no evidence of any objection on the docket of the Van Zandt complaint, and we know with the benefit of hindsight that the data was ultimately transferred. In the New York Times story, the reporters state that Jen Abel's texts were attached to Blake Lively's Civil Rights Department complaint about sexual harassment. Which is curious. Neither Jen Abel nor anyone from Jones Works was on the set of It Ends With Us in any meaningful capacity. The firm and Jen Abel herself were hired to deal with public relations and marketing in the lead up to the film's release. Their role during production was little to none. The evidentiary value of their documents and testimony on the alleged sexual harassment of Blake Lively on set is low. Blake Lively eventually did file a lawsuit that did require Jen Abel's texts. Her retaliation claim filed in the federal court, filed after the New York Times article was published. According to the New York Times, thousands of pages of documents from Jen Abel's phone was attached to Blake Lively's CRD complaint. Why? This leads me to conclude the Van Zandt subpoena exists not to support a particular lawsuit, but rather to protect the New York Times. The paper was preparing to publish deeply private information about a non-public figure. The existence of court filings provided the necessary legal privilege to shield that publication. By attaching the text to a later dismissed John Doe suit and a CRD complaint, the lawyers created a public record trail that the Times could report on. And with the notice of discontinuance, the data was effectively washed. Every attorney in the United States is bound by some variation of the same ethical rules, the American Bar Association's Model Rule, and what we see here is a conflict between two of them. Rule 1.3, the duty of diligence, is often referred to colloquially as a duty to zealously represent your clients. And Rule 3.3, the duty of candor to the tribunal, is being honest with the court. Manat issued the Van Zandt subpoena as a tool in its crusade to zealously represent its client who alleges they are the victim of sexual harassment. The candor and proper purpose of the complaint that was issued by Samantha J. Katz is questionable, as observed by the judge in Lively and Baldoni. but it was arguably a questionable tactic in pursuit of a proper cause. I have difficulty accepting this argument. Procedural oversights exist for a reason, and the Van Zandt subpoena appears to be an effort to avert due process. Whatever short-term strategic advantage is gained by such a maneuver is lost by the impact it has on your credibility to the court, and in law, credibility is everything. Here is the average salary of an equity partner in each of the firms involved with the issuance of the Van Zandt subpoena. Quinn Emanuel makes the most, with its equity partners apparently making $9 million each per annum, according to an interview with its managing partner. They're paid eye-watering sums each year to be the best of the best, and you'd hope that include being the most ethical. Attorneys are officers of the court. We grant them the power to issue subpoenas and seize data because we trust them to act as gatekeepers of a larger system. When those tools are used to wash private data into a public narrative, it doesn't just hurt Jennifer Abel, but the legal profession itself. So far we've talked about what happened and how it happened, but we haven't really considered the why. One of Blake Lively's central claims is that Justin Baldoni, Jennifer Abel, and Melissa Nathan, together with others, were all involved in the sophisticated clandestine technical smear campaign. This was the core of the New York Times piece, written by journalists Megan Twohey, Mike McIntyre, and Julie Tate. Leading the byline is Megan Twohey, who won a Pulitzer by being the journalist to break the story on Harvey Weinstein, effectively becoming a champion of the Me Too movement. So who better to report on a high-profile sexual harassment claim involving one of the country's biggest celebrities? But there's a problem. Irrespective of the conduct alleged on set, Justin Baldoni is no Harvey Weinstein. He does not occupy the same structural position of authority. While the accusations are serious, Baldoni lacked the industry-wide gatekeeping power or decade-spanning influence that typically defines a New York Times exposé. Before this article, Baldoni's biggest credit was his work as a supporting role in the Jane the Virgin TV show. He had also directed a few independent features. For a significant portion of the Times' readership, the article served as their introduction to Baldoni. In a town where sexual harassment is unfortunately common, this raises a tactical question. Why did this specific workplace dispute graduate to a front-page Pulitzer-level investigation? It's the retaliation campaign that elevates the story to the lofty heights of the paper of record. For a paper like The Times, the three-way intersection of celebrity, sexual harassment, and technical smear campaign turns this from a workplace dispute into a story of public interest. And the existence of documents obtained and vetted through court filings and subpoenas supports that narrative. But with the benefit of a year's worth of hindsight and unsealed court documents, the strongest evidence we've seen so far of a coordinated retaliation are still Jennifer Abel's texts. Private text between two publicists prone to exaggeration and inflammatory remarks. If there was a coordinated smear campaign against Blake Lively, it now looks quite like it was probably fairly old school, a whisper in the ear of a journalist, not the sophisticated technological effort reported in the Times. There are plenty of large, respectable papers who would have gladly picked up the story of Blake Lively's accusations and put it on their front page. Why go to the New York Times knowing they don't report on most sexual harassment claims in Hollywood? There are many, many sexual harassment claims in Hollywood, with stars as big or bigger than Blake Lively. Surely getting the attention of these journalists was an uphill battle. Why the extra effort? I don't know the answer to that, but I have one guess. And it has to do with the website, nytimes.com. When you use a search engine like Google, it will typically generate a list of hyperlinks and snippets in response to your query. This list isn't random. Its order is determined by a sophisticated algorithm to make sure you're getting the most accurate, helpful, and relevant information. And this algorithm can be gamed and manipulated through a process called search engine optimization. One of the key allegations in both Stephanie Jones's and Blake Lively's complaints is that Melissa Nathan engages in the dark arts of search engine optimization, planting negative stories and then manipulating the algorithm to ensure they appear first in search engine results. And it remains to be seen if this will be proven in court. But Jennifer Abel and Melissa Nathan aren't the only ones with an interest in search engine optimization. Indeed, SEO appears to explain why, of all papers, the lively parties gave Jennifer Abel's data to the New York Times. There are two concepts in SEO that interact here: EEAT and domain authority. EEAT is an acronym used by Google to describe experience, expertise, authoritativeness, and trustworthiness. Effectively, if deciding between two seemingly relevant options, Google will prioritize links that satisfy these criteria and place them higher in your search engine results. Certain websites consistently get strong EEAT and develop what external non-Google commentators describe as domain authority. Basically, commenters will assume these websites will be given a head start over others in the race to top spot of your search engine results. As of earlier this year, New York Times has a perfect domain authority score, 100 out of 100. By publishing a story in the New York Times, the lively parties weren't able to just manipulate the search engine results, they dominate it. In the world of search engine optimization, the New York Times is a nuclear option. In the eyes of Google's algorithm, what the New York Times prints becomes the canonical truth, a record so authoritative that even a subsequent court ruling may struggle to displace it in rankings. This is doubly true with the propagation of artificial intelligence. Recently, Google has begun placing Gemini results before a single hyperlink is displayed, and Gemini is going to pull its responses from sources with high EEAT. This may not have been just a leak of a public interest story, but also a sign of high-level PR architecture. By funneling this data through a platform with perfect domain authority, the lively parties have arguably executed a masterstroke in the PR Cold War by taking inalienable control of the search engine. But if that's what's happened, that means Jennifer Abel's entire private life was used as a commodity that could be traded ultimately for that domain authority. No one likes to think about data. In 2026, most of us have accepted that our data is constantly being collected. Our phones are monitoring us, our computers, CCTV, GPS. Very few of us are truly off the grid, and our data security is by no means guaranteed. In June 2025 alone, 16 billion user credentials were leaked globally. Statistically, you've likely been impacted by at least one data breach in your lifetime. And most of us are fine with that, or at least try not to think about it too hard. It's the price we pay for convenience. That's not to say we've given up on data security. Many of us change our passwords, implement two-factor authentication, and activate spam filters and use VPNs. It's a losing battle, but we try to cling to what remnants we have left of privacy, the scraps we can pull together and hold tight. There's an irony that the most ardent supporters of Jennifer Abel were likely the most excited to read Blake Lively's private texts with megastar Taylor Swift. Legal courts can and will compel disclosure of private information to the public, and that sucks, but it's a necessary evil for the pursuit of justice. However, it hits differently with something like the Van Zandt subpoena. This wasn't a court compelling a reluctant Jennifer Abel to hand over her text messages after hearing her objections. Jennifer Abel never got the chance to object. Jennifer Abel never got to weigh in on the proportionality of the requirement, how much data was necessary or relevant. For all she knew at the time of the New York Times article being published, they had all her data, unrestricted access to everything. The New York Times article references thousands of documents. How? There aren't thousands of documents of text relating to the Baldoni-Lively dispute. Looking at the actual CRD complaint, unsealed in federal court proceedings, the document is only 88 pages long. If the New York Times reporting is accurate, they saw exponentially more than we, the public, have. Some percentage of those documents that the New York Times was looking at were likely categorically private. But why should we care about one person's privacy? Like I said before, most of us have probably been the subject of a data breach at some point or another. Our passwords are floating around the dark web, waiting for someone to attempt to log into our old MySpace page. The striking element of the Van Zandt subpoena is that it's so human, so manual. This wasn't a failure of code. The Van Zandt subpoena represents a failure of conscience. One woman's privacy was dismantled by a committee of the country's highest paid legal minds. As I was finalizing the script to this autopsy, the judge dismissed Lively's sexual harassment claims on the technicality that she wasn't an employee of the film, but a contractor. They joined Baldoni's dismissed defamation claims, which were also rejected on technicalities of legal privilege. These are victories, yes, but hollow ones. The legal claims stumbling on tripwires. Baldoni's reputation may be irreparably harmed. Lively may live with trauma from her experiences on set. The emotional claims withstand despite the failure of the legal ones. The trial is set for May 18th of this year and will center not what occurred on the set of It Ends With Us, but the PR moves of Jennifer Abel and Melissa Nathan, and whether or not the alleged clandestine retaliation campaign actually occurred. We don't know what will come out of that trial, but it's worth considering if it matters. If Jennifer Abel is held to have participated in a coordinated smear campaign on behalf of her client, does that justify the legalized dismantling of her privacy? I don't know, but I don't think so, because the legal tactics used on Jennifer Abel can be used on anyone. In a community post, I joked this video was the conclusion to a trilogy. In my prior two videos about a charity boxing event and fair use, I concluded by criticizing systems, rules, culture, and norms. And it's the same here. The horror is the process. Any one of us can get chewed up and spit out by a dispassionate process, just like Jennifer Abel was. Thank you for watching.